Good morning, everyone. This is Rajeshkumar. Today, we are going to analyze one problem question, especially on the exclusion clauses. Disclaimer: the video content has been made available for informational and educational purpose only. Kindly go through it completely. Let's start with the problem question. Hassan is a big news reporter. He's 2 meters tall. His employer, Goodbye Magazine, is sending him to cover a celebrity wedding in the Bahamas. Hassan books his flight and a luxury room with a king-sized bed with a business travel PLC. A booking form which he signed includes the following clauses. Business travel PLC reserve the right to substitute any alternative accommodation for that booked. Class 2, Business travel PLC does not accept responsibility of any personal injuries suffered by their clients. While driving to the airport, Hasan realizes that he has almost run out of petrol. He stops at a garage and pays for 50 liters of petrol. Unfortunately, the pump malfunctions, and only 1 liter of petrol is put in his tank. As a result, he runs out of petrol and misses his flight. He is able to catch the next flight, but misses the wedding ceremony and only arrives in time to report on the post wedding party. After an exhausting day, he goes to the hotel to find out that he has been allocated a small economy room with a small bed. Hassan falls out of the bed in the night and breaks his arm. We have to discuss this issue and advise Hassan. Let's start with the analysis. Hassan's situation presents two major legal issues. One is exclusion clauses related to the booking with the business travel PLC and the remoteness of laws related to the malfunctioning of petrol pump. This analysis will address both aspects applying the relevant case law. The identification of breach and loss. There are the exclusion clauses in Hassan's contract with the business travel PLC. The business travel PLC has breached its contractual obligation by providing an economy room with a small bed instead of the luxury room with a king-sized bed that Hassan booked. This is a significant deviation from the agreed terms, resulting in both a financial loss, a payment for the lesser service, and a physical injury to Hassan's accident. Incorporation of exclusion classes. The term Hassan signed include two exclusion classes, allowing the business travel PLCs to substitute the accommodation and excluding the liability for any personal injuries. Generally, under Lee Strange versus Grugab case, a party is bound by the signed contractual terms, regardless of whatever they have read or understood them. Here, hasn't signed the contract, so prima facie, these clauses may be enforced. In other words, uh, Business Travel PLC breached the contract by providing Hasan with a small economy room instead of luxury room with a king size bed he booked. Given the Hasan's height, this is a significant issue, particularly because the accommodation was supposed to be luxurious. So, what is the validity of exclusion clauses? The clause was likely incorporated to the contract since Hassan signed the booking form as per the Lee Estrange versus Grigov case in 1934, where the court upheld that a signed a contract binds the parties to its terms, regardless of whether the person has read or understood them. Thus, Hassan may be bound by the exclusion clauses on substituting the accommodation. What about the interpretation of exclusion classes? The term Hasen signed include two exclusion classes, as we have discussed. The first class, which allows the business travel PLC to provide alternative accommodation, may seem to grant them discretion. However, under the contract law, the exclusion classes are often construed as contra preferendum against the party relying on them. So, therefore, this class may not justify as substituting a small economy room for a luxury room. Given the significant difference in the room type and the fact that Hosen bookings specifically noted a king-size bed, important due to his height, it is likely that this substitution constitutes a breach that class that does not cover. A second class, which exclude the liability of personal injury, require a close scrutiny under Section 2(1) of UCTA. A party cannot exclude liability for the death or personal injury resulting from negligence. Here, the business travel PLC substitution of the room created circumstances that led to Hassan's injury, suggesting a potential negligence on their part if they failed to provide a suitable accommodation. Therefore, this clause may not protect business travel PLC from liability for Hassan's injury. In other words, however, the courts often interpret exclusion classes narrowly. In Andrews Bros vs. Singer Co. in 1934 case, an exclusion class was limited in scope, but it did not cover all the liabilities. Here, the class allows the substitution, but does not specify that an alternative room can be of significantly lower standard. A court may find that substituting a luxury room with a small economy room is unreasonable or outside the scope of this class, particularly given the expectation of luxury. Let's move on to reasonable test under the UCTA. Under the section 11 and the schedule 2 of UCTA, the court must determine whether the exclusion clauses are reasonable. In assessing the reasonableness, a factor such as Hassan's expectation of a luxury room, his specific height requirements, and the significant difference in accommodation and quality would weigh against the class being reasonable. Consequently, it is likely that the class excluding the liability for Hassan's injury would fail the reasonable test, allowing him to claim damages for his injury. In other words, the Section 3 of the Unfair Contracts Terms Act 1977 apply to the standard terms in the contract between the business and consumers. Under this provision, the class will be enforceable only if it meets the reasonable test of Section 11 of UCTA. The court will consider factors like the parties' relative bargaining powers and whether the term was fairly communicated. Given that Hassan's specific needs, his height, and the promise of luxury accommodation, it is possible that the class may fail the reasonable test and rendering it unenforceable. So, to conclude, the business travel PLC substitution of the luxury room for a small economy room likely constitute a breach, and the exclusion clauses may not apply due to the statutory protections under UCTA. Hassan could therefore pursue a claim for both his financial loss and his injury. So the Hassan's injury, falling out of a small bed and breaking his arm, raises the issue whether this exclusion clause is valid in limiting the liability for personal injury. Section 2(1) of UCTA explicitly prohibit exclusion of liability for death or personal injuries resulting from negligence. If Hassan can demonstrate that this injury was caused by negligence, such as a provision of an unfit bed, and business travel PLC cannot rely on the exclusion clauses to avoid liability for his injury. Additionally, under Section 2(2) of UCTA, exclusion clauses that limit the liability for loss or the damage other than the death or personal injury are subjected to reasonableness test. Since Hassan injury is personal, the clause is likely void. Let's start with the remoteness of damage for the missed flight. The garage failure to provide agreed amount of petrol constitute a breach of contract. As a result, Hassan ran out of the fuel, missed his initial flight, and consequently missed reporting on the wedding ceremony, limiting his coverage to the post-wedding part. In other words, Hassan missed his flight due to the petrol pump malfunction, which resulted in his arriving late to the celebrity wedding. The key issue is whether he can claim damages for this loss and whether those damages are recoverable under the principle of remoteness of loss. Application of doctrine of remoteness. In determining the damages, the remoteness test established in Headley versus Baxendale requires that loss must either arise naturally from the breach, or B, within the parties, contemplation of time of contracting. Here, while the loss of £50 for the fuel can be considered a direct loss, the missed flight and the missed wedding coverage represent consequential losses. In Victoria Laundry versus Newman Industries, the court awarded damages for the lost profit as the seller knew about the buyer's need for timely performance. In other words, the remoteness of laws, as per the Headley versus Baxendale in 1854, the court held that damages are recoverable only if they arise naturally from the breach in the ordinary course of things, or if they were in the contemplation of the parties when the contract was made. In this case, Hawson loss, missing his flight and the wedding ceremony, would not naturally flow from from the malfunctioning of petrol pump. So, applying the Victoria Laundry versus Newman's Industry case in 1949, a damage for the consequential losses must be within the reasonable contemplation of the parties. A garage cannot reasonably foresee that a failure to the petrol pump would result in a missed flight for a news reporter covering a high profile event. Therefore, the missed flight and its consequences are too remote, and Hassan is unlikely to recover the damage for this loss. Similarly, in Heron 2 in 1969 case also established that damages are not recoverable if they were unusual or unlikely. In this case, while missing a flight may result from running out of petrol, a garage could not have known that Hawson was in a rush to catch a flight for an important assignment. The court would likely find the damages to be too remote. In other words, in Victoria Laundry versus Newman Industry case, the court awarded damages for the lost profit as the seller knew about the buyer need for timely performance. Similarly, in Heron 2, it was held that loss reasonably foreseeable as a serious possibility could be recoverable. A garage might reasonably foresee that insufficient petrol could cause travel delays, but whether it could anticipate Hassan's specific need to cover the wedding in Bahamas is debatable. To conclude, the garage could be liable for the fuel cost and any direct loss from the breach. However, Hassan missed flights and resulting inability to cover the wedding may be deemed too remote to be recoverable as the garage was unaware of his specific travel obligations. So, Hassan is unlikely to recover the damage from the garage for the missed flight due to the principle of remoteness of loss. The consequences of the malfunction were not reasonably foreseeable by the garage, making the loss too remote to claim. To conclude, class 1, the accommodation substitution. While the classes was incorporated into the contract, it may fail under the reasonable test in UCTA because substituting a luxury room with a small economy room was not a reasonable given the nature of the contract. The class 2, the personal injury exclusion. The exclusion class for personal injury is void under section 2.1 of the UCTA. Therefore, Azan can likely claim damages for his broken arm. The petrol pump and the missed flight, Hassan cannot recover damages for the missed flight because the loss is too remote under Headley versus Braxendale and Victory Laundry. The petrol station could not have foreseen such a consequences from the malfunctioning pump. So the come to the first point, the Hazan is likely entitled to damages for the breach of accommodation contract as ECTA limits the enforceability of their exclusion classes. He can claim for the financial loss for the lower quality room and for his injury due to the unsuitable bed. Comes to the claim against the garage. Hazan can recover the direct losses such as the petrol cost, but it is unlikely he could recover for the missed flight at the wedding coverage due to the remoteness, as these losses were not within the garage reasonable contemplation. So overall, the Hazan has a strong claim for the broken arm, but the limited prospect of success regarding the missed flight. The exclusion clauses in the contract with Business Travel PLC are subject to strict scrutiny under UCTA, and at least the personal injury exclusion clauses is likely void.